66. My DOC is 115897.
Together, would you sit up and let's have a conversation? From your DOC, I mean, you've been in the game for a while.
Yes, sir.
That true?
Yes, I have.
Let me explain the process to you, Mr. Gilbert. I will read some information into the record. Once that information is in the record, we'll conduct a thorough interview with you. At the appropriate time, we allow the staff at Claiborne to have comments or remarks. Again, we'll hear from the Assistant District Attorney from Jefferson Parish, Mr. Randy Myers, who would like to make a statement. At the very end, before we vote, we will allow you to make a statement on your behalf. You understand the process?
Yes, I do.
Mr. Gilbert, your master record indicates that you're a second felony offender. Your offense is armed robbery. You were sentenced on December 18th, 1986. You received a 99-year sentence without benefit of probation, parole, or suspension in sentence. Your parole date was November 4th, 2011. Your good time date, and I'm going to check that with your master record. The good time date is September 19th, 2039, and your full term date is August 27th, 2085. Is all this information correct?
According to my rap sheet, yeah. But the Social Security number that's on that rap sheet is incorrect.
Have you tried to correct?
It says that the Social Security number on it is incorrect.
Have you tried to correct that?
Yes, I have. In 1993, I did.
Okay.
And
well,
they never.
If criminal parole doesn't take care of those matters, then you need to talk to your classification officer, okay?
Okay.
Mr. Gilbert, your case has been assigned to me, and let's start the conversation by telling us how old you are, Mr. Gilbert.
I'm 55 years of age.
55 years of age, and you've been incarcerated for the last 36 years on a 99-year sentence for armed robbery. Is that correct?
Not exactly 36 years, but 35. August the 29th of this year here would be 36 years.
Right. And I rounded off because August is right around the corner. So basically 35 years is about 9 months.
Yes, sir.
So let's talk about your program. Tell me some of the programs that you've completed in the 35 years and 10 months that you've been incarcerated.
I haven't participated in any of them except Thinking for a Change. That was the only one that was taking that Angola.
Yeah, and that amazes me. You've been in state facilities almost 32 years. You first went to Angola in 1987, and I think you had state facilities until you left 2017. So why didn't you take the programs that were necessary to rehabilitate yourself?
Well, sir, number one, I'm actually innocent on this charge. I'm actually innocent on this charge.
Okay,
And
that's something that this committee doesn't handle.
okay, well, I just want to complete what I want to say.
Go ahead.
I had a writ pending in court, and I had a response from the United States Fifth Circuit Court of Appeal in January of 1993 through a classification by the name of Vernon Smith. And
Now, that does not have anything to do with this hearing.
I understand that.
We're here to see
I'm
whether or
only
not-
saying why I haven't participated in the program.
Okay. So basically, you were in state facilities from 1987 to 2017, 30 years, and you completed one program.
Yes.
Was it maybe because that you were maybe in extended lockdown, or you were in working cell block a lot of that time?
Yeah.
Mr. Gilbert, you've lost 1,245 days of good time because of disciplinary problems. That equals to 3 years and 5 months off your good time date.
Yes, I know, and that's because they've been treating me unhealthy and in gold. I never received a double portion, and I just couldn't push myself to work like that.
How many write-ups do you think you've had in 35 years of incarceration?
No, I wouldn't. I would say less than 100.
Less than 100. When was your last disciplinary write-up at any institution?
I don't remember the exact date of it, but it was at Rayburn.
So it was before 2017. Is that correct?
What date was it?
You went to St. John the Baptist in October 2019. So that's when you left Rayburn in October 2019.
Right, correct.
You don't remember when you had the write-up?
Not the exact date on the write-up.
Was it in 2019?
It was in 2018.
Okay. Now, so tell me what your education level is.
I completed school when I was in society.
So you have a high school diploma?
Yes, I do. Not in my prison files here, I don't. But I completed school. And I also have an auto mechanic trade.
Your master record says that you completed the 8th grade.
I would say that's incorrect.
Okay. Tell me about the organizational activities that you participated in the 35 years of incarceration.
I haven't participated in any of them while I was incarcerated.
Tell me about the community service that you performed for fellow offenders while you were incarcerated.
None.
So tell me about your transition plan. What do you plan to live and what do you plan to work if and when you're released?
Well, I would be self-employed. I have a will and I own my own business.
What kind of business?
Well, I own service station, I own a shopping mall, and I'm a self-employed mechanic. I was before I was arrested on this.
Who's been operating your mechanic shop in your mall?
No one has been operating my mechanic shop. The gas station is the service station is a real estate.
Tell me about your job at the facility. What do you do on a daily basis?
What could I do on a daily basis?
What is your job?
In prison?
Yes.
I don't have a job in prison. Not here at Claiborne.
What do you do 24 hours a day?
Well, I don't do anything in there but sit around in that dome and be to myself.
Have you ever had a mental health evaluation?
Yes, I have. At Rayburn.
And what was the result of that evaluation?
He told me there was nothing wrong with me.
You've never been on mental health medication?
No, sir. See, they can't relate.
Looking at your arrest record, you were arrested 11 times between the ages of 17 and 19. 9 of those arrests, the charges were dismissed or refused by the Jefferson Parish DA's office. You only had 2 convictions on the record, even though you were arrested 11 times. Do you think that getting charges refused or dismissed multiple times encourage you to do other crimes, like rob the Shell station?
I've never been a criminal. I never robbed the Shell station. And I can't explain all of them arrests because it was all the devil being against me. And that's the best thing I can see on my behalf.
Thank you, Mr. Gilbert. The staff at Redwood make any comments or remarks, and let us know if there's any mental health issues that we should address.
So I'm not familiar with any health, mental issues or anything. I do know I spoke with the lady in the classroom and she said that he did refuse every class offered to him.
He has been offered classes, and he's refused class.
Well, I would say this. Can I say this on my behalf?
Yes, sir.
I want you to hear me carefully. When I came to jail, I was free on the inside. About in December of 1996, I ate pringles. It was around Christmas time. I ate pringles and other snacks, and a buffer was introduced into my system. And that caused me to be possessed. And due to this thinking of this other person, it,
Gilbert,
it interferes
Gilbert.
with my
Mr. Gilbert,
education.
Mr. Gilbert, I'm gonna end your statement right there.
Okay.
There's no further questions at this time. We're going to hear from the Assistant District Attorney in Jefferson Parish, Mr. Randy Myers.
Good morning, Randy Meyer, Assistant DA, Jefferson Parish, and we're strongly opposed to his request. The victim knew Mr. Gilbert from being a regular customer at the store that he robbed. He obviously has taken no programs to try to rehabilitate himself or try to even help himself. Even, you know, if you accept his position, I didn't commit the crime, he's still done nothing to help himself throughout this thing, and he's lost over 1,000 good days with none restored. Those reasons we're strongly opposed. Thanks.
Thank you, Mr. Meyer. Mr. Gilbert?
I don't care about this.
Mr. Gilbert?
The judge calling you.
I'm listening to you.
At this time, you are afforded a brief statement. If you start rambling and talk about other things that are not germane to this hearing, I will stop you. Give us your closing statement.
Well, you say it's not related, but it's all related to my case. And according to the response that I received from the judge, I don't know why I'm going before a parole hearing.
Thank you, sir. Are we ready to vote? Mr. Gilbert, based upon a disciplinary conduct that's unacceptable, based upon a lack of rehabilitative program, based on express opposition from law enforcement in the DA's office, my vote is to deny your request. Mr. Freeman.
Based upon you not trying to take any classes, also your denial of the instant offense, I also vote.
Ms. Jackson.
Mr. Gilbert, I feel like in some ways it's fallen through the cracks. From talking to you, it's obvious that you need some mental health treatment. And I hope that you're in a place where there is that available.
No, I don't need any mental health treatment.
The person who needs the treatment is usually the last one who recognizes it. I don't feel like you're equipped in any way to be. You don't have any family support. You don't have any job skills. You are suffering from mental illness, and I don't think you can take care of yourself in the world. So my vote today would be to deny your request for early release, but I would strongly urge the facility, if you have that ability, to have him undergo a mental health evaluation.
I don't want the parole.
Hey, that's all right.
Mr.
Okay.
Gilbert, this morning you have received 3 votes to deny your request. Your request for early release has been denied. Here with that.
I never requested.
Okay. That concludes our business at Fairbourne.
Well, when you think you've seen it all, Louisiana proves you wrong. This isn't the first time we've had a parole hearing similar to this where someone has said, I don't want parole, but I think it's the second. And to start off with, you might be wondering, I know I was like, maybe he is innocent. Maybe, things were going well for him and he was locked up for a crime he didn't do. And man, if I was, I might act the same way. I might be not wanting to take programs and feel. I was trying to feel that way, but and Richard pointed out in the notes, it lists in the documentation he didn't own the pump station. He was a manager. So we start to unravel and we'll go through the documentation here, like what Randy Meyer, the ADA, said, talking about the crimes, where it's pretty certain that he is guilty. The next thing that you need to bring up, though, is should he be in prison or should he be in a psych ward? And frankly, from what we've seen, it's psych ward written all over it. I couldn't believe he he starts to talk about what was it, like 1997 or 1998, and I was kind of like pulled into his story, and I'm just think for a second that was like 22 years prior, and he's saying it as if it happened yesterday, and he's saying that he's eating his Pringles and snacks, and then he became possessed. And I would have loved to have heard the rest of his story about that. But come on, let's be real. I don't think, and as Miss Jackson said when she suggested that he needs psychiatric help, and then he said, I don't need it. And she said, well, it's the one who needs it that is the last to know that they do. And we saw a glimpse into, again, I think, a problem of the system. This man, if anyone should be in a psychiatric facility, it would probably him, but he would probably be very unhappy in one and much rather stay where he is. So that's the catch-22, right? But man, you've got to assume that someone unless he does get psychiatric help, even who knows, but he's gonna be locked up for the rest of his life, because pretty clear that has no chance of making it on the outside. So here's the information that Richard found. We'll go over his case. So facts. Sorry. Can you see it? Try to zoom in a little more. There's like a delay when I zoom it, and see that delay? Okay. The armed robbery of the Roadshell service station of Jefferson Highway took place at about 10:30 p.m. See, now it's just zoomed in again like a minute later. On August 28, 1986. Just think about that. A man entered the cashier area wearing a hat and a handkerchief folded into a triangle that covered his face from nose to chin. Joseph was on duty alone, preparing for his relief to come at 11 p.m. The perpetrator held a revolver and said, "All right, this is it." He then told Shields to go towards the bathroom behind the cashier area and ordered him into the ladies' room. Shields heard him attempting to open the computerized cash register, and a few seconds later, the perpetrator told Shields to come out and open it. He put the pistol to the back of Shields' heads, cocked the hammer and told him to hurry up, and said, "Do you hear it click, bitch?" I didn't say the whole word. I just abbreviated it for those who are wondering. Shields opened the register, and while he was answering the telephone 1186, the perpetrator removed cash and checks from the drawer. He left through the front door, at which point Shields called the police. A total of about $800 was missing from the register, and at some point the perpetrator had taken Shields' wallet containing about $80. That's a pretty good score, $800. $880, 1986, yeah. From robbing a gas station. Shields was positive that the robber was a young man he had seen and waited on several times, and who was known as the Crazy Wayne. He might have been known as that. He might have been crazy all along. He is said to have recognized him from the upper part of his face, his body build, and his voice. He was unable to recall the perpetrator's clothing. The police knew of Crazy Wayne as Wayne Gilbert and arrested him the following morning. At trial, only Shields and a sheriff deputy testified for the state, but the defense presented 8 alibi witnesses who testified to having seen him or been with him at the night of the crime. Gilbert did not testify in his own defense. That's a lot. Eight alibi witnesses. Wow. They put up a real defense here. I mean, you don't often see that. The crime of which Gilbert was convicted is armed robbery. So that was it. They just found him guilty. The defense complained specifically that the perpetrator was not sufficiently identified as the victim saw only the eyes of the perpetrator for only 15 seconds and heard his voice. The only palm print taken from the ladies' room door did not match Gilbert's. The state produced neither the stolen money nor evidence showing, hey man, maybe I'm going to be convinced otherwise. I mean, he's wearing a mask and the guy said that he knew it was him, but that's easily, I mean, it's definitely easy to believe that it wasn't him. He came into the parole hearing slumped back in his chair with all the attitude, and Mr. O'Shea's like, sit up. And I'm wondering, I'm like, wow, this guy doesn't want to get out. It's quite remarkable, right? I think he's the definition of being institutionalized. Shields testified that he's seen Gilbert at Station 3 to 4 times a week over the preceding 2 or 4 months. There was a small convenience store in the office, and Shields had waited on him, usually viewing him from a distance of only 8 to 24 inches. They had conversed, and he was familiar with his voice. On the night of the robbery, the cashier's area was well lit with fluorescent lighting. Despite the handkerchief and hat, Shields stated that the upper part of the thief's nose, his eyes, and most of his forehead was visible. The hat was not pulled across his eyes. Although they were face to face for an estimated 15 seconds only, Shields has ample time to hear the voice as he kept talking and telling him what to do. The witnesses further explained that he had an occasion to ask the defendant his name on one occasion when he waited on him. The defendant gave a name other than Wayne, and another employee who was present confirmed that the customer was Wayne. Shields testified that helped to cement the identification of him, and I had seen him a few times around the edges of the property after that. He explained his inability to remember the type of shirt the perpetrator was wearing because his attention was focused on the face and not the clothing. I would have thought he'd say the gun. But again, that can be coached. A little bit of coach witness, right? I don't know. 6 of the 8 alibi witnesses all covered the defendant for the hours of 10:30 p.m., although the stories were conflicting. And 1187 rambling as to timing other than 10 to 11 p.m. And as to other details of the evening, they had seen him at the home of 3 of the witnesses before that time, and sometime after 10, 4 of them and Gilbert went riding to Bourbon Street, returning after midnight. And that could be the problem with the defense. When you bring up all those witnesses, they kind of will cancel each other out if they're conflicting and not strong. That could be the problem. It's probably better to bring in just 2 witnesses that can have the same story. Faced with contradictory versions of the evening's events, the jury weighed the credibility of each witness and eventually believed the testimony of Joseph. It is not the function of the appellate court to assess credibility, and it will not be viewed sufficient as evidence. Defense complains that the sentence of 99 years without benefit of probation or suspension of sentence is constitutionally excessive. He also asked that we examine the record of error to patent, and I would agree, man. It's like, it was a bad crime. It is armed robbery. It's traumatizing, but the idea that you get 99 years is just absurd. It's like you can get 25 years, okay? 99 years. we've seen people get shorter sentences for taking lives. It's just crazy. Now, I'm not saying if he had gotten out, one would assume he'd be locked back up pretty much immediately. So, this is just a lost cause. In this case, before the record does not reveal the defendant was apprised of his rights. Da da da. Oh, okay, they're talking about the different appeals. We'll go to the next. See what's here. Here they give a little bit more information. So he was 20 years when he was charged with armed robbery. 20 years old, convicted by a jury in 1986 and sentenced to serve 99 years. Okay. In 3 years since you've become an adult for criminal purposes, your record is absolutely one of horror. You've committed batteries and burglaries, although you have only one conviction, that being the conviction before Judge Tiemann in April of 86. Subsequent to that conviction, while you were on probation on the 28th day of August 86, it's alleged that you committed armed robbery. Despite what you tell the court, this court is absolutely convinced that you are the offender in this particular situation. The court is also convinced, likewise, that your prior juvenile record indicates not only your total disrespect for the law, but your total disrespect for the rights, property, privacy, and safety of others. Further, this court is convinced that your prior records, your rehabilitation cannot be accomplished, and you have indicated no ability to be rehabilitated. You have neither sought rehabilitation. Because of your prior records, I'm convinced that society would suffer because of your activity. Society does not have to tolerate that type of activity or have people like you in the community. Accordingly, under the guidelines and having considered all of the mitigating circumstances, this court specifically finds that there is an undue risk that the period of suspended sentence probation you would commit another crime. This is indicated by your present criminal record and your juvenile record. You are in need of custodial environment, provided most effective by your commitment to the institution, which would neither lessen nor depreciate the seriousness of your crime. Mr. Shields, the manager, here it is, where it shows. Oh wait, no, this is not. This is Mr. Shields, the manager of a service station, was held up at gunpoint. It was only by the grace of God that the gun did not go off. The judge set out the three circumstances under the convicted felon. I might say, well, he didn't pull the trigger, but at the same time, when you pull the hammer back, it's anything can happen at that point. I doubt he had good trigger discipline. Yeah. Anyways, it's something that, what can you say? It does seem clear that he needs psychiatric help. But even then, can you get to the point where you can be paroled? I don't know. That would certainly be amazing if we saw him all of a sudden a bunch of years later and he was functioning properly. But I guess because of Act 122, he has a good time date. He's not. And that's why he has the opportunity for parole here. But the fact that he's lost 3 years and 5 months of good time, it can make us appreciate the others that have gained good time, right? With that, I'll let you go.